I thank you, and I thank the other witnesses. The chair will now recognize himself for 5 minutes for the purpose of questioning the witnesses. Professor Luban, you've written that the lawyers advising the Bush administration on the legality of U.S. interrogation policies, including Alberto Gonzales, David Addington, Jay Bybee, and John Yoo, showed a, quote, willingness to bend or break the law to make their clients' wishes come true, unquote. Can you give a couple of concrete examples of ways that the law was bent or broken by their advice?
Yeah, here a couple of examples would be this. Mr. Yoo's two memos, the March 14th, 2003 and August 1st, 2002, both make an extraordinary claim of executive power, which is that the president acting as commander-in-chief can simply override any statute in the book, including the statute on torture. Now, a lawyer is supposed to present adverse legal authority as well as legal authority that supports the view. And here there are leading Supreme Court precedents that just say the opposite, the famous Youngstown case. But there was an 1804 case called Little versus Bareem from the quasi-war with France, in which Congress had restricted what the Navy could do. President Adams ordered a captain to violate that restriction, and the Supreme Court said that the president's order was not a shield against liability. Those cases aren't even mentioned. That's the kind of thing that is a violation of the craft value that lawyers have. Now, second would be this drawing of the definition of torture from a Medicare statute. The Medicare statute says quite commonsensically that severe pain can be the symptom of a medical emergency. Mr. Yoo turns this around and says that unless the pain is organ failure or death, the level associated with organ failure or death, it's not severe. When Mr. Levin withdrew that opinion and replaced it with another, he said quite plausibly, that Medicare statute wasn't trying to define severe pain. I mean, if you took that literally, then you would think that, for example, if the dentist's drill hits a root and you jump out of the chair, well, you know that's not organ failure or death, so that's not severe pain. Okay. And that simply violates common sense.
Thank you. And in your article, Liberalism, Torture, and the Ticking Time Bomb, you say that it would be a dramatic mistake to suppose that the Justice Department has abandoned its views merely because it has disowned the Bybee memo. Can you briefly explain what you mean? I mean, why you think it's clear that the Justice Department has not abandoned its views?
Yeah, for a couple of reasons. After the Bybee memo was withdrawn, then the Levin memo was substituted. The Levin memo says in a footnote that all of the techniques that had been approved under the Bybee memo are still approved. As for the commander-in-chief override argument, the Levin memo doesn't disown it. It says, well, there's no need for us to discuss it. As for the criminal defenses in the Bybee memo, it doesn't reject those criminal defenses. It just says, well, since we don't torture, there's no need to discuss those. And finally, in the one place that it completely stretches the law is in its definition of what severe physical suffering is. It states that severe physical suffering has to be prolonged. Now, if you look at the statute, that isn't in there at all. It was mentioned that by Congressman Franks, I believe, that everybody who's been waterboarded broke in less than a minute, and it looks as though that language would say, well, therefore, waterboarding can't be severe physical suffering because it wasn't prolonged.
Thank you. Ms. Cohn, does the Military Commissions Act give officials of the Bush administration immunity from prosecution under the War Crimes Act?
No. While we would argue that attempts to immunize those complicit in torture from criminal or civil liability is not permitted under the doctrine of jus cogens, the Military Commission Act does jus cogens, J-U-S-C-O-G-E-N-S, Latin for the highest compelling law, like slavery, genocide, and wars of aggression. But no, the Military Commissions Act does not provide immunity for prosecution. What the provision does is to provide that good faith reliance on the advice of counsel would be a defense to war crimes prosecutions. But it could be proved that they were not acting in good faith reliance on the advice of counsel for several reasons. Number one, the advice was inherently and flagrantly not a good faith interpretation of the law. Number two, they all knew that, and that's why they performed this so-called analysis in secret, avoiding all the normal processes that they usually use to arrive at these decisions. And number three, they lied about the matter both to the people within the administration and the public, making numerous false exculpatory statements which can be considered evidence of guilt.
Okay.
So the administration's effort to avoid accountability under the Military Commissions Act is further evidence of their guilt and can be used as an overt
now,
act of conspiracy.
one more question before my time runs out. In the attachment to your testimony, you outlined the case for criminal prosecution for the lawyers involved in the formulation of the interrogation policies at issue. From what U.S. laws and precedent do you draw your conclusions? In other words, under American law, how could administration lawyers face criminal liability for their counsel?
We have statutes that prohibit conspiracy. For example, the torture statute, which is a U.S. law, prohibits the conspiracy to commit torture. And it would be, I think, not difficult to show that these lawyers were part of a conspiracy, a common plan. In fact, John Yoo said we had a common strategy here. They got together on it. So I think that it clearly could come under a conspiracy laws, that they would be part of a criminal conspiracy to violate U.S. laws against torture.
Thank you. Just one further question. How long is the statute of limitations on these crimes?
The statute of limitations under a use Cogan's prohibition is never. There is no statute of limitations at all for violation of a use Cogan's norm.
Thank you.